to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam from the American Bar Association's Antitrust Law section. Today's topic is Why the Pushback? Understanding the policy challenges to the eBooks enforcement case. My name is John Roberti. Today we're going to talk about the policy implications from a fairly recent enforcement action by the Department of Justice involving eBooks. And frankly, it has been a widely criticized case, both from the left and from the right. What we want to talk about today is what is the nature of these criticisms, and we have a guest who will say that the criticisms actually represent a fundamental misapprehension of important antitrust principles. So we'll look forward to that. My co-host is Kayla Odom. Hi, Kayla.
Hi, John.
Kayla, what are we covering today?
Well, we're going to take a closer look at the United States versus Apple eBooks case. And this price fixing case was interesting not only because eBooks are pretty commonplace now, but because the case really brought antitrust law to the forefront for many Americans. That's why the case was so compelling. How could you not see a violation of the antitrust laws? And indeed, in the end, the judge did find a violation. Yet somehow, the case tested the public's perception of the role of antitrust laws when it comes to innovators and technological advancement.
You know, Kayla, you say it was a clear-cut application of the antitrust laws, but I think what's interesting is you heard a lot of voices saying that it's really not true, that it was actually a misapplication of the antitrust laws. It's a very controversial case.
And that's why it's worth a deeper look.
Absolutely. Well, who's our guest today?
Today we have Chris Sagers. Chris Sagers is the James A. Thomas Distinguished Professor of Law at Cleveland State University, where he's taught courses in various subjects, including antitrust law, business organizations, and law and economics. He's testified before Congress and the U.S. Antitrust Modernization Commission. He is an elected member of the American Law Institute, a senior fellow advisory board member of the American Antitrust Institute, and is the author of several books, his latest entitled United States versus Apple, Competition in America. Thanks for joining us today, Chris.
Hi, thanks very much for having me.
Well, it's quite a coincidence, Chris, that we are talking about the Apple eBooks case, and it's something you've written a book about. Could you tell us a little bit about what got you interested in the Apple eBooks case?
Yeah, I mean, initially it was exactly what you and Kayla both said, which was, and Kayla said it well, that when the complaint came out, when the facts became public, and they hadn't been. I mean, there was a DOJ investigation that was a private thing, non-public thing for a while. But nobody really knew what was going on. And then the complaint hit the internet, and people were kind of flabbergasted to see these pages and pages of details of corporate executives doing things that seemed sort of brazenly illegal. And so to antitrust lawyers, it seemed kind of like a slam dunk kind of case. It's the one category of conduct that we all usually agree ought to be illegal. So that was kind of interesting in itself, although it kind of seemed a little mundane, frankly. It was just a price fixing case. But then almost immediately it became clear that actually all kinds of people didn't think it was an easy case at all. So what was fascinating initially was just the disconnect between the strong views of the antitrust bar and the views of basically everybody else. And that seemed like it had to be interesting. And over time, it came to seem to me that it was interesting enough for a whole book.
Chris, if you could take us back a few years to 2012, 2013 area, when this case sort of started, Can you go over a little bit of the background of the case? Who are the parties and what were the main issue?
Yeah, sure. The book is a deep dive history, and the history is really fascinating. We don't have time for all of it, but the very short version is that the Apple computer outfit, got itself caught having coordinated an agreement among 5 major publishers of books, and those 5 controlled a very large portion of all trade books in English. So meaning like general interest books in English. And the details are hairy, but the agreement essentially fixed the retail price of the books that they would sell as eBooks. And it was this all happened in connection with Apple introducing a product that at the time was revolutionary. It was the iPad. There hadn't been a viable tablet computer market before then. And Apple set up this deal to inaugurate the iPad as the second major distributor of ebooks. At the time, the only distributor was Amazon. So they fixed the price of retail books not only on the iPad, but also on Amazon. They pulled it off. Nobody seems now to doubt that the conspiracy amongst the publishers themselves, the agreement about their retail prices was per se illegal. But the big difficult question in the case was, well, what about Apple? Not a horizontal competitor. Antitrust lawyers all thought this is just a garden variety hub and spoke case. Apple coordinated a per se illegal conspiracy, so it has the same liability. But a lot of people thought, maybe this isn't a case like that.
Chris, when you say a hub and spoke conspiracy, just so I know what you mean,
Sure.
it's like a bicycle, right? Where the hub is at the center and the spokes are around it. Is that how it works?
Yeah, right. Just to explain it to you, John, the hub is any person who helps coordinate what otherwise would be a horizontal conspiracy. A lot of times, deals, in fact, in the classic hub and spoke cases, deals are set up just like this. The horizontal competitors tend to avoid talking to each other directly because everybody knows it looks real bad. And is potentially like criminally illegal and so on. So it can be convenient for them if some other player who isn't a horizontal competitor, and often it is a downstream distributor like Apple, shuttles between the horizontal players and communicates for them, transmits assurances amongst them that they'll all agree to the same price and so on. And the courts have said when that's the case, it really just is an agreement amongst the horizontal competitors, and the agent that helped them set it up is just as liable as everybody else.
The relationship between Apple and the competitors, the structure where Apple was in the market versus, the publishers.
Sure.
Where the publishers were in the market versus where Apple is in the market. Did that change how the agreement was evaluated?
Okay, so that's a very good question, and it depends on who you're asking. Did it change how the agreement was evaluated for the trial judge who oversaw the case, Denise Coate of the Southern District of New York? No, it didn't. She heard ad nauseum arguments from the defendants and their many defenders in the public that because Apple's relationship was quote unquote vertical, that there must be something very special about its role, and we ought to be much more careful about preserving its ability to establish what might be pro-competitive arrangements or things of that nature. She was unpersuaded. The Justice Department likewise was unpersuaded. The Court of Appeals ultimately also was unpersuaded. So, I mean, the short answer is that for the people who matter in terms of deciding who's going to be liable, no, it didn't matter. Mattered a lot to a lot of other people. And in fairness, a lot of smart, perfectly competent, good faith people thought maybe there's something special about Apple's non-horizontal role that ought to call for more deference here.
Was there anything memorable or remarkable about the trial?
That's a good question. It's sort of remarkable that it went all the way to full judgment on the merits by Judge Coate, and that Apple stuck it out all the way through denial of certiorari. I mean, the publishers settled before trial, and one might have expected Apple to do that too, because the facts were not really in a lot of doubt. Interesting. There's an interesting question, I think, about why Apple did that. A lot of people thought, eBooks are at the time and still eBooks are a relatively small market, and they would never have probably amounted to more than a tiny piece of Apple's overall business picture. And so a lot of people thought, why are they putting so much into this? And one thought is, it was because at the time, this model in which Apple is coordinating content deals such that it is assuring itself a privileged position as a distributor of content, free of hot price competition, specifically from Amazon and other companies like Amazon. That may have been a pretty important thing to preserve for Apple. So a thought is that even though eBooks probably weren't that important to the Apple company, maybe they stuck this out so long because they hoped to defend a model that could be very much more lucrative to them in other sectors. And in particular, at the time, there was the thought that Apple might become a major distributor of streaming video. Whatever's the case, though, even the antitrust cases don't go to the merits very often, especially clear-cut ones. So that was kind of big. The other amazing thing to me, though, and again, part of why I wrote the book was that the trial itself attracted not just so much attention. Antitrust cases tend to be big cases and they get a lot of attention, but kind of crazed attention. People were obsessed with this case. And a lot of people were very angry at the Justice Department and angry with Judge Coate for her apparent sympathy with the Justice Department. This all sort of invites discussion of what was the real elephant in the room, which was an entity that was not a party to the case, but was sort of visibly present in the case all along, and that was Amazon. People were freaked out about Amazon, and they thought that a case like this might help Amazon be an even bigger monopolist. So, a remarkable thing was just how obsessed people were with the case.
Was that obsession due in part because people are obsessed with Apple or obsessed with Amazon as companies? And
yeah, surely both. Apple is it's a marquee company. It's very sexy. Steve Jobs was alive at the time, and he had sort of a personal role in the case, as people may recall, though memories are receding. He had said some things publicly that seemed really clearly to acknowledge that there had been an illegal conspiracy. And those, even though he died before the time of trial, those statements were a part of the government's case. But then Amazon, I think, is the big deal. People are scared of Amazon, and Amazon was to a large part what the case was about.
Chris, I want to go back to something you said a little bit earlier about bringing the case could have strengthened Amazon's market position. What's wrong? I thought antitrust laws were designed to facilitate competition. Yeah. So wouldn't this be effectively an anti-competitive use of the antitrust laws? Is that a criticism that people raised?
Yeah. So very interesting, and that goes to the heart of the issues in the book, and also highlights another reason that the whole thing was so interesting to me, because I agree with you. There were many critics of the Justice Department's case who said, look, you morons, you are using the antitrust laws perversely to effectively help the company that's the real big bad monopolist in this case, specifically Amazon. They said, defenders of the defendant said, sure, they set up a price fixing conspiracy, but they only did it because they had to protect themselves from Amazon's what was essentially a monopsony kind of behavior by Amazon. Amazon's forcing down the wholesale price of books so far and killing the publishers in their overall business. And I have the same instinct that it sounds like you're saying, which is, wait a minute, all Amazon really seems to have done, at least as far as any solid evidence shows, is sell a great product at a low price. And that if the Justice Department is helping Amazon in any way, it's only helping Amazon to keep doing that. So that makes sense. Okay, this is part of what made the whole thing fascinating to me, because suddenly I was talking about this case like I was Robert Bork. That's just not the kind of thing you hear progressive whack jobs like me talking about.
Oh, I thought you and Bork were simpatico on most issues.
Bosom buddies, John, as you know. But and on the other hand, though, I mean, I felt weird talking like that, and I still do. But on the other hand, a lot of the people saying, no. The bad guy here is Amazon. And the real problem here is Amazon's super low prices. I mean, there were a lot of people using the PP word. There were people saying Amazon is engaged in predatory pricing because the prices it's selling its ebooks at are so low. And in fact, perhaps they're selling them at a loss. A lot of the people saying that were like big law defense lawyers. I mean, that's crazy. You have people who, generally speaking, it's hard to persuade them that any conduct is anti-competitive. It's hard to persuade them that the size of a firm, the mere size of a firm, could ever be a competitive problem. And they're talking about this case like they're Louis Brandeis. So it was just a crazy case that threw a lot of people into weird positions. One of my favorite parts of the case was, so we go through a full trial, we go through appeal in the Second Circuit. The Second Circuit affirms Judge Coate in a strongly worded opinion, but it drew a dissent, and that the dissent was very strongly worded. And that one judge who doubted the government's case wrote about the case again, like he's a populist progressive reformer. He said the real problem is Amazon, the problem is low prices. He was talking about it in just the same language as the very progressive antitrust advocates who are prominent now, who hated the government's case because they said it was just an inadvertent, assist to a big monopolist. He talked about it just like they did, but he was Judge Jacobs, a very conservative Republican appointee who, he spent his whole career in a very large corporate defense firm. So a lot of strange bedfellows, and I just thought that had to mean that there was something deeper that was very interesting.
And how's the eBooks market doing today? And do you think that this case sort of had an impact on where it is today?
Yeah, that's very interesting. Interesting on two levels. First of all, so one thing that one might have expected from the government's successful litigation of the case would have been that Amazon went back to price discounting, and that ebooks continue to be super, super cheap. That may have happened for a while after during the period in which the government secured a consent decree that forbids some of the defendants' practices. But it definitely hasn't continued. So ebook prices right now depends on where you do your shopping, but they're not low. And in fact, they're often fairly close to the hardcover price or the going market price of whatever the hard copy is. For example, my book is available for purchase on Amazon at like $1 less in ebook. And I'll confess, I don't exactly know why that is. But in any case, another thing didn't happen that a lot of people thought was going to happen, which is, throughout the pendency of the case, we heard that, low price ebooks, these allegedly predatorily priced ebooks, are going to kill the publishing industry, and they're going to kill paper books. They're going to be the end of hard copy books. That emphatically didn't happen. Even during the period of the consent decree, when Amazon was selling books more cheaply, ebooks grew as a share of the book market overall, but never came close to displacing paper books. And it's clear that paper books are going to survive, at least for the foreseeable future. Another institution that plainly is going to survive, that at least for a while, that a lot of people thought was doomed, is the independent bookstore. Like a lot of the appeal, a lot of the popular appeal gotten by critics of the case, people who said this is a bad case, a lot of the appeal was based on the fear that Amazon was going to destroy independent bookstores. And there was plenty of reason to believe that might happen. Independent bookstores really were suffering severely for the first decade of this century, and for a while after this case. But surprisingly, and much to my very happy delight, they've bounced back. They're on the rise, and it's interesting how they've done it. The evidence so far, it's new. This is a new trend. Who knows what's going to happen? But the evidence so far is that The independent bookstores that are back and that are doing well are bookstores that do something special. They do something Amazon can't do. They do something other than just delivering a product at a low price. So in other words, their success to me is sort of a nice reaffirmation that we can actually kind of trust markets to do things. In other words, if people actually want something, if they want like a well-appointed local store where there are smart salespeople or there are local events or there are book signings or whatever, markets can actually supply that even when there are big firms that are competing on price and quality. So I'd say the book market's doing just fine.
If you could predict the future, do you see ebooks sort of taking over? I know you say right now there's a nice balance, but do you see it moving more electronically?
Yeah, hard to say. I mean, to some extent, I think, the market test that we have right now, in other words, the observation of the real world, probably is a little bit misleading because there's still a lot of restraints surrounding ebook markets. For one thing, they're pretty tightly controlled with, intellectual property, but also with DRM technology. So there are things that ebooks can't do right now because of legal constraints that would make them probably even more desirable to people and might make them a bigger threat to hard copy books. And then again, for whatever reason it's happened, the pricing just hasn't gone back to where it was when Amazon was really on fire. If Amazon had kept selling books at $9.99, which was the trend, we probably would be seeing a different market. I think for the foreseeable future, people do actually like books. At least old farts like me like physical books. I do some ebooks, but I'd really prefer to have a paper book, and I think a lot of people are like that.
Chris, I want to ask you a little bit about the antitrust policy here. We had a podcast earlier this year where we talked about whether the European Union should allow certain mergers to allow European companies to be a better counterweight to China. In the U.S., we've heard of proposals to allow, for example, certain horizontal competitors to band together to do certain types of purchasing or things like that when you have a large monopolist seller. It sounds a little bit like some of those policy considerations came into play in the case that you analyzed. Mm-hmm. Is that good policy? If you have somebody who has, outsized market power, shouldn't antitrust take their foot off the gas on some of the enforcement to allow, others to catch up?
Yeah. So I humbly submit that it's terrible policy, and the evidence that exists is against it. So just unpacking that a little bit. I mean, so you suggest, and some people say that we need to have bigger firms in the U.S. or in Europe to compete with, to be competitive with foreign firms. Okay, so the evidence is actually against that. Such comparative evidence as there is supports the idea that more competitive domestic markets make domestic firms more competitive overseas. So, and it's obvious why. Firms disciplined by competition are better able to hold their own. And they're, furthermore, despite what a lot of people say, there just isn't solid evidence that scale economies improve after relatively modest size in hardly any market. So do you need a 4-firm domestic oligopoly to compete overseas? I seriously doubt it. And you definitely don't need firms bigger than that. Okay, the separate thing you're saying, though, is really a lot more generally. Nowadays, we are hearing a lot of people in a lot of different markets saying, you have to let us get bigger, or you have to let us avoid competition because we face a monopolist at a different level in our chain of distribution. You hear this all over the place. Newspapers right now want a statutory antitrust exemption that'll allow them to bargain collectively with the big tech platforms over advertising revenues. Doctors for years have been trying to get an antitrust exemption that lets them bargain like a union with HMOs or insurance companies. And I mean, you can sympathize. I definitely sympathize. I think it's terrible if if you're a supplier and you're trying to sell your product to Amazon, and you feel like the only thing you can do is team up with your fellow suppliers and refuse to let Amazon have its way with you. The problem is, if we say, okay, fine, that's going to be our policy going forward, whoever feels like they're threatened can band together to fight market power. We're not going to end up with a competitive market. We're not going to end up with anything that's beneficial to you and me. We're going to end up with a series of bilateral monopolies who really have no interest except fighting with each other over how big a slice of the consumer surplus they get to keep that they just squeezed out of people's pockets. So, I mean, the answer to me to those kind of problems seemed real simple. The answer, when there's a monopolist at one level in a market, the answer is not to let people at other levels in a market become monopolists too. It's to break up the monopoly or to do something about the monopoly. To some degree, that's what my book is all about, precisely that problem. And we could talk forever about it. But yeah, I feel really strongly about this. And the bilateral monopoly solution is like the worst possible competition policy we could have.
Is that the role that you would say that antitrust laws should play in the technology sector or in any sector?
Yeah, definitely. I mean, so it's like people said the problem, and some people now, including some academics, some experts, again, with across the political spectrum, are saying the problem in a case like Apple is that we're obsessed with preventing cartels. We're obsessed with preventing horizontal collusion, and we don't control, without controlling other things. I say the problem in Apple is not that we sued a cartel. We totally should sue a cartel. But we have other parts of our antitrust law. Specifically, we have a monopolization law and we have a merger law. And you can't just go after the cases that are low hanging fruit. And that's the problem. The low hanging fruit is the cartel cases. If the government never sues anybody for anything else, you're going to get situations like Apple, where you have sort of a sympathetic argument for disadvantaged persons dealing with the monopoly. And they're going to say, wait, you let this big firm get so big that it can really abuse us, but you're not going to let us take self-help measures. So, my answer is enforce all the antitrust laws.
So would you say the level of enforcement has changed in more recent years?
Yeah, I mean, that's there's probably fighting words to some listeners of this podcast, but yeah.
I did not know that about you. Chris, before we go, we want to have our listeners learn a little bit more about you. But before we do that, could you just tell us the name of the book, where we can find it if we want to read it?
Yeah, absolutely. Thanks very much. The book is called United States versus Apple: Competition in America. It's available from Harvard University Press on their website, and it's also available wherever you buy your books, Amazon and elsewhere. Amazon's real cheap, by the way. Interesting thing has been to watch the pricing algorithms. I have no idea, but they're selling it real cheap. So,
well, that'll be the one for the next podcast. Chris, let's turn and look. You're a law professor. Mm-hmm. I know you love your job. Tell us why.
Oh yeah, so many reasons, and I couldn't possibly say them all. I'm saying this here. I say this in my classes too, but here you can be sure that I'm not saying this just because I'm trying to butter up the people who write my evaluations. Really, the best part of it is the students, and that was an amazing thing to me. I mean, I went into teaching like a lot of people, wanting to write the papers and the books and not really knowing if I would even like teaching or be any good at it. And that turned out to be better. I mean, you're with young people at this formative part of their lives, and they don't know what a big change they're in for, and you get to be part of it with them, and it's the best.
Chris, what advice would you have for a younger lawyer that's interested in getting into teaching antitrust or consumer protection?
Yeah, sure. I want to be encouraging, but my honest view is if you want to teach antitrust, you might want to think of teaching something else. Unfortunately, the law schools have decided, along with quite a lot of the rest of the world over the last many years, that antitrust maybe isn't that important. And so they have not seen it. They've seen having an antitrust professor on faculty as something of a luxury. So if you can pair it with something the antitrust, that the law schools want, like corporations, which is what I did, corporations securities regulation, that'll help. But more generally, the key to everything in law school hiring now, aside from just having, like, if you can walk on water, that does actually help. But if you can't, at least get the best clerkship you can and get the best grades. But once that's all on your resume and you can't change it anymore, the best thing you can do is write.
Great. Chris, one last question before we get to our final segment, and that is, tell us something surprising or unusual about yourself that we wouldn't know if we only knew you professionally.
Yeah, hard. I mean, again, so many things because I'm a weirdo. I was a music major who hadn't had a math class since high school when I went into law school, and one of my lowest grades in law school was Antitrust, and so here I am, defying the predictions made by facts.
See, Chris, so I happen to know that I have seen your Facebook page, so I actually do know there's more to you than that. But I suppose that would violate some sort of privilege, and we won't do it. So we'll just go to our last segment, which is called The Curious Hat.
And now it's time for The Curious Hat.
Chris, in the studio here, I have an actual hat that has actual numbers with them, and I am going to ask you to choose a number. I will pick that number out of the hat, and I will ask you the question associated with that number.
It has absolutely got to be 19.
Okay, question number 19. Okay. Chris, what is your favorite cuisine?
I think I have to say sushi, which we make at home, by the way. And so far, I do not have a liver parasite, but we do make it at home, and it's really delicious.
Do you make that sushi that if you don't make it exactly right, you die in 30 seconds?
Yeah, the blowfish, I think. None of that. You may die from my sushi because, after all, I'm cooking it. But so far as I know, none of it is.
When you're cooking your sushi, because I don't think...
You know what I mean.
No.
Cutting it up. I'll tell you.
Okay.
First time I had sushi, I was like, you cannot tell me they didn't do anything to this. They just cut a fish open and it tastes this good, but it really does.
When you make your sushi...
What's your role of choice?
My role of choice? That's a good question. We make this thing that I fondly call the hot dog roll, but it doesn't taste like a hot dog. It's smoked salmon mixed up with mayonnaise and a Chinese garlicky spice as sort of a paste. Defendants.
Do you ever buy like the super on sale fish and then use it for your sushi?
No, I do not.
Because
advice to listeners: only buy salt. I learned this from a doctor. Only buy saltwater fish and you're fine.
Even like really old saltwater fish, you're okay?
Okay, be realistic. But the dangerous pathogens are in freshwater fish.
And with that, we come to the end of another episode of our Curious Amalgam. Thank you for listening, and we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.